original, mighty the god, the magical radical. Representing my magical, young Jose come million. Jamaica wacha, that defta, kina teach me kenyo Jamaica kopa. That wacha, kina damage me kenyo Jamaica wacha. That defta, kina teach me kenyo Jamaica kopa. That defta, kina damage me kenyo.
Gangsta de kamele mele, deya, eja kaman deya, we are deya for the bed. The heaven they say you're my baby. Every day I call you my blow, you're my treasure. Baby got your machina yo, baby kwakana yo, baby chamo chonkola, baby got your machina, baby got your kwara. You are say bandada, you must say bandova, you must say bandada. Baby got your tema kama kwakala, baby tema kama kwakala, tema kama put it on my baby.
Good morning, welcome to my YouTube channel. My name is David Okon. I'm talking in the UK about work, and today we'll be talking about fixed term contract. And we are looking at in a situation where an employee is dismissed at the end of the fixed term contract. Stay tuned, continue watching. So the expiry of a non-renewal of a fixed term contract is a dismissal. In other words, if you have a fixed term contract in terms of employment, and if it comes to an end and it is not renewed, then you are dismissed immediately without more. It may be fair or unfair, depending on the circumstances. However, because of a fixed term contract, the way it is defined, it ends. It has a defined end date, and it ends on a completion of a particular task. No extra notice of dismissal is needed if the contract is allowed to run until the defined date or the ending of the task. So let us look in fair detail how unfair dismissal operates within this sector of employment status. So a client will be dismissed if their contract reaches the end of a fixed contract term and is not renewed. So the ending of a task contract, ending of a task contract because the work has been completed is also a dismissal. The client may, if they meet the qualifying conditions, be able to claim an unfair dismissal. However, non-renewal of a fixed contract term may be a fair reason for dismissal depending on the circumstances. When calculating a client's continuous employment to see if they have worked long enough to claim unfair dismissal, you should add together all the periods they have worked for that employer, provided there was a break between the contracts. Normally, continuity of employment may be broken by a gap or a break of more than 1 week, but continuity can be preserved in some circumstances. If you are of interest in this topic, you can look more about the continuous employment. Let's also look at non-renewal of a fixed term contract, which is done because of the employee is pregnant. This is a situation where women may be in a situation of being dismissed one way or the other. So a dismissal resulting from the non-renewal of a fixed-term contract may be unfair if the reason for it is connected to the client's pregnancy. Stay tuned, continue watching. It will also be unlawful sex discrimination if someone else was taken on to do the same job immediately after the client's dismissal. This may indicate that the non-renewal is an unfair dismissal and discriminatory, although this depends on why the contract was for a fixed contract term and what was said to the employee. The European Court of Justice, ECJ, has ruled that it is unlawful to dismiss a woman because of the pregnancy, even if she was employed on a fixed-term contract and was unable to work for a large part of that contract because of her pregnancy. We are looking at dismissal and pregnancy. There can also be a waiver of unfair dismissal in fixed terms contracts if the fixed term contract began on or after 25th October 1999. Waiver clauses for unfair dismissal are no longer valid. This is because this is the case whether the fixed term is a renewal of an existing contract or whether it is a completely new fixed-term contract. It also applies regardless of the length of the fixed-term waiver clauses in contracts of less than 1 year. If this is the case where waiver clauses in contracts of less than 1 year were not valid anywhere even before this date. Looking at redundancy, a client will have been dismissed if they come to an end of the fixed-term contract and it is not renewed. There are special rules if the contract contains a waiver clause about redundancy. Looking at conditions for claiming a redundancy payment. Therefore, waiver clauses for redundancy for fixed-term contracts where we started renewed. We started a contract for a fixed-term contract started, renewed or extended before the 1st of October 2002. In this circumstance, the employee has a waiver clause in their contract which states that they are not entitled to a statutory redundancy pay, where the waiver clause will be still have effect if all the following apply. So under these circumstances, we would have the waiver clause being in writing, and also the fixed term contract is to last for 2 years or more. The contract was entered into or renewed before October 2002, and also the waiver being the clause. The waiver clause being to exclude the right to statutory redundancy pay, which was included in the contract before the 1st October 2002. We may argue that it is not necessarily clear. It's not clear whether waivers apply where the contract is renewed for less than 2 years, or where each one of the individual fixed terms are each for less than 2 years duration. To stay tuned, continue watching. So where the waiver or the waiver terms meets the rules of above, the client has no right to claim a statutory redundancy payment. The reason for the non-renewal of the contract is generally irrelevant. The only occasion where it might be relevant is if there is a possible age, disability, gender reassignment, and also civil partnership, pregnancy and maternity, race, religion or belief, sex or sexual orientation discrimination. For example, if the client is able and they are dismissed while non-disabled employees of their contracts renewed, they would be able to bring a claim for disability discrimination to a tribunal. You can also look more about discrimination at work generally. Looking at the waiver clauses for redundancy for fixed-term contracts where it started, renewed or extended on or after the 1st October in 2002, it's from the 1st October 2002. Any waiver clause relating to redundancy is in fixed-term contract where the contract is agreed, renewed or extended on or after this date will have no effect. This means that from this date, employee on any of these fixed contract terms will be able to claim statutory redundancy pay provided they have a continuous employment of 2 years or more. Also, from this date, employees on task contracts where there is no specific date for the contract to end, and where the contract lasts for 2 years or more, will have the right to claim statutory redundancy pay. In many cases, the reason for non-renewal of a fixed-term contract will be redundancy because, for example, the task has been completed and therefore the employee is no longer required to do that particular type of work. As a general rule, therefore, a fixed-term employee whose contract starts or is renewed on or after the 1st of October 2002 will usually be entitled to statutory redundancy pay if their contract is not renewed when it expires, provided they have worked for at least 2 years with the employer. Therefore, we are looking at a situation of continuity of employment for 2 years as a condition, and when should we continue watching. Stay tuned. So stay tuned, continue watching. Thank you so much. And if you haven't subscribed to this YouTube channel, please subscribe to the channel, click like, click notification bell, leave a comment below and share with family and friends. If you have watched, if you are new, you're welcome to this channel. Thank you so much. Then you can subscribe to support this program. If you're a returning subscriber, then you are so warmly welcome, and I'm so grateful that you came. We are here talking about work in the United Kingdom, and like I said previously, let us look at what happens in the United Kingdom in law, and also compare the same with what happens in Europe and elsewhere in the world, such as in the European Union, and also the rest of the European area, in America, and in the rest of the continent, including Africa. Because what happened in the United Kingdom in terms of employment law also happens in across the globe because of globalization as a political system, and also within the global system of where capitalism is practiced, employment is becoming a private sectoral component within the industry. And I've already said previously that employment by way of policy and politics should be looked at in terms of economic development, and also in terms of welfare system. A lot of people consider employment to be an economic factor without considering a social factor, where employment is the primary source of income in a country, as much as also if served to develop the economy, producing growth within capitalism, which is an appropriate thing. And except that, you know, within the marketized system of the economy, the wealth, although generated in an economy, is not fairly distributed because of the private sector. The private sector protect the market system by operating private companies whose primary interest is to make profit, and not minding of the welfare of the majority of the population in terms of nationhood. And this is a problem which I have raised consistently within this program of work, and also financing for the majority of the population in a country. Stay tuned. Thank you so much. Let us go back to looking at the specific, looking at fixed term employment and certain claims when there are issues of employment contract arising due to certain rights being given contractually and also others being given statutorily. We are going to look at a state of affairs where employees who are employed on a long series of fixed contracts become permanent employees. If you have been employed on a fixed term contract for a long time, there is a possibility for the law giving you a right to become a permanent worker, employee in a company. Let us look at the EC directive on which the regulations are based, requiring that employees should not be able to keep employees on a successive fixed term contract and thereby deny the employees their rights to full employment rights. The directive imposes a limit to the number of fixed term contracts on which an employee can be employed. This is a European community directive which is actually giving power in favor of employee, which I tend to agree with. If in practice it is applicable, it is implementable as it is in favor of an employee, as you will see. And so you can take a note that there is no limit in the regulations as to how long a first fixed term contract can be. The rules about an employee are changing from being on a fixed term contract to being on a permanent contract, only aimed at employees on a successive fixed term contract, succession of a fixed term contract, meaning there is one fixed term contract after another. There is no specificity how long that successiveness may or may not occur. So let us stay tuned to continue watching. If an employee meets the following conditions and the contract they are on is deemed to be on a fixed term contract by the employer, it will not be treated as such, and it will be deemed to be a permanent contract by an employment tribunal. This is the kind of guidance. Stay tuned. Leave a comment below. Let me know your thought about this state of affairs. Therefore, however, a workforce agreement may apply. The conditions are the employee must have been employed on more than one fixed term contract by the same employer. So we are talking about continuity of fixed term or succession of fixed term contract within a year. If there is more than one successive fixed term contract, then these rules apply, where the employer would be given the right to become a permanent worker or a permanent employee. So these fixed term contracts must have been successive. That is, the employee must have been continuously employed under them with any breaks between successive contracts being less than a week. So it is a continuity requirement, looking more about continuous employment within law, and when added together, the total length of the fixed term contracts must be at least 4 years. Note that continuity of employment when calculating the 4 years starts from the 10th July 2002, so that employment on fixed term contract before this date does not count toward the 4 years. The employment of the employee on a fixed term contract must not be justifiable on objective grounds. If an employee's contract meets the conditions above, the term of the contract that arises to limit its length will have no effect, and the contract will be treated as a permanent contract when it is renewed. If it is renewed before the 4 year point, the contract becomes permanent as soon as that 4 year point is reached. If it is renewed after 4 years point, it becomes a permanent. It becomes permanent on renewal. the employee will be entitled to the usual employment statutory notice for dismissal. As look about notice of dismissal, the regulations allow collective or workforce agreements to be drawn up in the workplace, which can vary the rules above. Employers and employees can agree on any mechanism that satisfies a limit on the number of successive fixed-term contracts, a limit on the length of successive term fixed-term contract, objective reason justifying the renewal of the fixed-term contract. So we are looking at when what an employee can do if they should be deemed to be on a permanent contract. Continue watching. Thank you so much. So let us look at what an employee can do if they should be deemed to be on a permanent contract. Stay tuned. If an employee meets the conditions above and believes they should be treated as a permanent employee, they should have the right to apply to an employment tribunal seeking a declaration that their contract is permanent. Before doing this, they must be of a written request to their employee. They must make a written request to their employer for a statement as to the status of their employment contract. That is whether the employer views them as a fixed-term employee or a permanent employee. The employer must then provide a written statement within 21 days of the employee's request, confirming either that the employee has a permanent contract or giving reasons why the contract is still a fixed-term contract. So if the employer does not reply to the employee's request, this does not automatically convert to the employee's contract from a fixed-term contract to a permanent contract. However, a tribunal can draw whatever inferences it sees fit from the employer's failure to respond to the employee's request. Stay tuned, continue watching. So let us look at 0 hours contract as a type of employment status. As we may from time to time be checking on employment statuses, looking at exclusivity statuses, clauses, problems with 0 hour contracts, challenging a 0 hour contract. 0 hours contracts are contracts where both the following apply. Someone's agreement to work depends on the employer supplying work. In other words, if there is no supply of work, then the contract ends. There is no guarantee the employer will supply work. A 0 hours contract could involve your client, when you are employed as a 0 hour contract, your situation may be where waiting at home by the phone to see if you may need to come into work. In a situation where there is no work, you keep on waiting, you will not be able to work. That is the nature of 0 hour contract. It's also a situation where having a clause in the contract which states that the working hours for the week will vary and will be determined each Monday morning. So in a week, you will not be able to know how many hours you will work and I will be determined on a weekly basis on a Monday morning, and also you will be waiting on work premises to see if there is any work to do. So apparently you go to work not knowing if there is going to be work, and you wait there. If there is no work, then you will come home without any work. And leave a comment below, stay tuned. This is what 0-hour contract means as an employment status in the United Kingdom. And you will comment if this is a situation in your country, but that is what is happening now in the United Kingdom. So we are going to check employment status. People working on 0-hour contracts can be employees. They can also be workers. They can be self-employed, depending on the circumstances. You should also check your employment status to find out what your rights are. You need to check not just what any written contract says, but you also check what happens in practice. You will also need to check your status when you are working and between periods of work. Because there are situations when you will be working. There are also situations when you are moving between works or between periods of work. You need to know what your status would be when you are moving, for example, between works. Maybe you have done work in one place, and then you are working, and then the periods between work, when you are not working and when you are working, the period when you are working and when you are not working, from one period when you have been working to another period when you are working, that period when you are not working, you should know your status, whether you are employed or not, and your rights also. So the most important factor to consider when deciding if you are in a situation on a 0-hour contract is an employee is mutually of obligation. Mutuality of obligation means there are two contractual obligations. One for the employer, one for the employee. So the employer must provide a guaranteed amount of work and pay. You should also, you must also do the work. If there is genuinely no mutuality of obligation between your client and their employer, and then you as a client, as the prospective worker, is unlikely to have a contract of employment, and you will usually be a worker because of your circumstances. There are two ways in which you might be on a where you may be on a 0-hour contract, and you can show that there is a mutuality of obligation. The first, if it looks like there is no mutuality of obligation in the contract, look at whether what actually happens suggests there is a mutuality of obligations. Therefore, you have to be a detective, as a worker, or as an observer. Leave a comment below what you think this is a situation in terms of people working in the United Kingdom. So you first, if it looks like there is no mutuality of obligation in the contract, you look at whatever whether what actually happens suggests there is a mutuality of obligation. Think about how you actually get or do or keep the work. The way you get a work, you get a job, the way you do the work, the way you keep the work is a sign how you get it, how you do it, how you keep it in terms of working. This will demonstrate where there is whether or not there is a mutuality of obligation under a 0 hours contract. For example, do you on a day-to-day basis on a shift do you book your shift in advance? These are some of the questions you need to check whether you book your shifts, whether you have to book your shift in advance, whether you keep in touch with the employer when you are not working, and whether you tell the employer when you want to take time off, for example, for holidays, and there might be enough mutuality of obligation for a contract of employment to exist, even when you might be in a situation whether you are not working. So in this situation, there is a global mutuality of obligation, and the second scenario would be even if there is no global mutuality of obligation, there is a mutuality of obligation when you are in a situation of doing the work, where you have to do the work, whether you are actually in a situation where you are doing the work. So there could be no contract at all when you are in a situation where you are not working, but there is a continuity of employment which is not broken. Therefore, this is because the gaps are a temporary cessation of work or an absence by arrangement or custom. So you might be having a right, whether you have it or not will depend on your employment status. So if you are in a situation where you are in a 0 hour contract as an employee, you will acquire the same rights as the other employees. Your rights will be based on the number of years of service you have done. So employees on 0 hour contracts may also acquire other entitlements in relation to pay or other benefits on a pro rata basis when compared to full-time employees. Looking at 0 hour contracts, where there are often part-time contractors and therefore the right of part-time workers not to be discriminated against when compared to full-time workers may be useful when arguing for pro rata contractual employment rights. Stay tuned, continue watching.
Some see the original, mighty the god, the magical radical. Hey, representing my magical. Young Jose, come milli. Jamaica, wacha, that difta. Kina teach me kenyo Jamaica kopa. That wacha, kina damage me kenyo Jamaica wacha. That difta. Kina teach me kenyo Jamaica kopa.
So stay tuned, continue watching. We are looking at work, we are looking at employment contract under the 0 hour contract in the United Kingdom. Leave a comment below if you have a condition similar to the one in the United Kingdom, whether you live in Europe, whether you live in Africa or elsewhere, wherever you're living. Let me know if you are in a situation where you also have to face a circumstance involving a 0 hour contract. And like you have in the United Kingdom, that is what we are talking about now in terms of contract. And let us find out also more about the rights of part-time workers under something called exclusivity clauses within the 0 hour contract or obligations and rights. And if you are in a situation where you might have a clause in your 0 hour contracts, 0 hours contract, and which says you can't work for another employer or can only do so if your main employer allows it, then you do an assessment as to rights. Stay tuned. Thank you so much. So, like I was trying to say, if you have a situation where you are working as a 0-hour contract employer or also employee, you might have a clause in your 0 hours contract which says you cannot work for another employer, or you can only do so if your main employer allows it. So you are not free, therefore, to work for another employer, unless your employer with whom you have 0-hour contract allows or give permission for you to do so. And in these circumstances, this state of affair is called an exclusivity clause. That is what exclusivity clause means. If you are in a situation where an employee, as an employee, you whether you are if you are in a situation where you are an employee or a worker, and your employer cannot enforce an exclusivity clause, and if you are actually an employee or a worker, your employer cannot enforce an inclusivity clause under these circumstances. This means you are in a situation where you cannot be stopped from working for another employer. This is a noteworthy point. Is a bit convoluted. Leave a comment below. Let me know what you think about these conditions under the 0-hour contract, which is increasingly becoming a major issue in the UK employment law, which is from time to time is a very oppressive contract type, which is very actually very corrupt. If you may ask me, I don't like employment 0-hour contract at all, because it is it's almost, you could say, such a contract should be stopped straight away. In my opinion, is from the devil. It's not from a human being. It's a very evil system which oppresses people who are vulnerable already, people who are low paid, people who face a lot of uncertainty. There is always an argument of flexibility, but I disagree, that because flexibility can be done within the main system on contract, especially if you are a worker, you can still be flexible. And it's not why should an employer not make an employee flexible in working, unless the contract is zero hour. So let us continue. Stay tuned. Continue watching. So let us see in a situation where if you are an employee, and dismissed for breaching an exclusivity clause, that will be an automatically unfair dismissal, and it is also unlawful to treat either a worker or an employee or an employee badly because they breach an exclusivity clause. And there you go. So you can also look at certain problems associated with a 0-hour contract. A worker or employee on a 0-hour contract, 0 hours contract, is entitled to be paid at least the national minimum wage. Working time for this purpose include time spent actually working, traveling during work, and say, for example, if you are actually traveling to work, if you are actually moving from one place to another during work, you are traveling during work, and you are supposed to be paid waiting at work. To find out if you are being given work, you should be paid under these circumstances. Even if you are then sent home without work, you should still be paid for the period you have been traveling and for the period you have been working. So the employee cannot count themselves as laid off or put on short time for the periods they are not working. So this means they cannot claim a guarantee payment, a payment made to an employee to keep their services during a period of layoff or short-term working. Guarantee payments are only paid if the employee's contract specifies normal working hours which they are not working. This would not be the case for an employee with a genuine 0-hour contract. Stay tuned, continue watching. So let us look at the holiday pays. All workers, including employees, are entitled to statutory pay holidays. This includes a person working under a 0-hour contract. Problems can arise when trying to work out how much holiday a worker is entitled to if they are irregular hours. They're working irregular hours, so to speak. So we try to find out more about holidays pay, and one way it is said, one way is to calculate holiday entitlement that accrues as hours are worked. So if you work for hours, then the entitlement for holidays can be accrued. Let us look at statutory sick pay also. Now, in statutory sick pay under a 0 hours contract, someone working under a 0 hour contract is entitled to receive a statutory sick pay if they are eligible. For the purpose of statutory sick pay, a worker, including an employee, will be eligible if they are an employed earner. If you earn as an employed person, then you will provide an eligibility and also entitlement for sick pay, statutory sick pay. So a person is an employed earner if income tax is or should be deducted from their earnings under the pay as you earn scheme. There is something called pay as you earn, your payee scheme. A person on a 0 hours contract is most likely to encounter problems gaining entitlement to statutory sick pay because they may not have worked enough hours to meet the earnings condition for statutory sick pay. These are some of the problems associated with 0 hour contract in relation to statutory sick pay, because the conditions are so poorly worked out such a way that those on 0 hour contract are most likely to lose out on certain vital benefit. Even if they're entitled, it may be very complicated in practice to implement on certain benefit of employment, as we have just seen. So we can also find out more about statutory sick pay and who is entitled to it under this condition. So we are looking at notice pay. Notice pay under this condition of 0 hours contract. So if an individual on a 0 hour contract is an employee, they will be entitled to statutory notice of dismissal. If they don't work normal hours, normal working hours, they will normally be entitled to notice pay based on an average of their wages in the previous 12 weeks. So talk about average pays in a 0 hour contract situation and the benefit of other of certain awards or such as notice pay. If the individual is generally a worker, they are entitled to statutory notice of dismissal, although they may have a right to notice in their contract. This is because of a condition of 0 hour contract. So find out who is excluded from statutory notice and how to calculate notice pay. You can also challenge a 0 hour contract. Every employee and worker must be given a written statement of their terms and conditions of employment. This statement should include the terms and conditions relating to hours of work, including normal weekly hours, if there is any overtime requirements, the scale or rate of pay, whether pay is weekly, monthly, or paid at some other specified interval. Although this statement isn't the contract, it is very good evidence of what what is in the contract per se. If a contract doesn't specify the number of hours to be worked each week, but merely says that hours of work will vary each week, it is still a legal contract. If an employee on a 0 hours contract habitually works the same number of hours each day or week over a length of time, it will be easier to argue they are not 0 hours. You should look for evidence that the written contract doesn't reflect the true relationship between the parties. Examples of evidence might include: stay tuned, the employee always doing the same hours without being asked, the employer demonstrating an expectation that the employee will return on a usual day, for example, being told on a Friday, see you on Monday, so expecting them to return on Monday, the employer refusing any request to vary hours or early or leaving early, the employer leaving early, the employee having a request to request the days they are normally expected to work off as holiday, the employer getting other people to work the days they are normally expected to work if the employee is unavailable to work those days. If it can be established that an employee has been working regular hours and they are offered no more work, although they are willing and available, they may be entitled to be paid for the hours they have come to expect. This is a difficult argument to make, as you would expect. An employee in this position who wants to argue that they should be paid for the time they have not worked should be referred to a specialist employment advisor. When you are being referred to an employment advisor who is a specialist, that means this area of law involves a lot of complexity. In practice, it is not really obvious that you are going to get access to a specialist employment advisor. So without more, under this situation in practice, these circumstances involving our contract is reflect a failure of policy without more. Stay tuned, continue watching. Continue watching. We are still looking at employment statuses and the rights pertaining to these employment statuses. We are looking at apprentices in the United Kingdom in terms of employment, in terms of work. We do the normal checking of eligibility. We will check if someone is in a situation where they are on apprenticeship. Normally, it is important to do a check. And you will check also to look at pay and minimum wage pay, also the length of contract, the training, and the safety of an apprentices in a situation where there is a strike, whether they are allowed to strike or not. Employers' insolvency, when an employer becomes an insolvent, we are looking at transferring an apprenticeship to another employer. We look at discrimination, redundancy, dismissal when an apprentice can leave. What happens when the contract expires? These are all the elements to look for. So apprenticeship are a way to gain paid workplace experience while studying for qualifications. An apprenticeship is a set of qualifications called a framework, usually comprising a national vocational qualification (NVQ). Leave a comment below if you have a similar equivalence of NVQ in your country, especially if you are in Africa or somewhere in Asia. Looking at transferable skills, for example, communication, IT, etc., technical certificate, and apprenticeship are available in all sectors and industries. They are generally falling into one or three categories. Apprenticeship equivalent to GCSE, this is O-level equivalent. Advanced apprenticeship are equivalent to A levels in terms of academic registration or measurement. Higher apprenticeship equivalent to a degree in a small number of sectors. The learning provider delivers the knowledge and develops skills, while the employer provides practical experience. Training can be classroom-based in a workshop or in a workplace, depending on the subject and the learning provider. Let us look at eligibility criteria. Different apprenticeships have different entry requirements depending on their frameworks or standards. The most important requirements are that an applicant must live in England, not be taking part in full-time education, be age 16 or over. If an applicant already has a degree, they won't be eligible for funding. They can still study for an apprenticeship if an employer agrees to cover the cost of training. You can find out more about eligibility for apprenticeship on the UCAS website. You can also check if you are in a situation of apprenticeship. It's important to check if you are in a position where you actually are an apprentice, or merely a trainee, as this will affect your employment rights. There's a difference between an apprentice and a trainee. All apprentices are employees, but an apprenticeship contract differs from an ordinary employment contract. It gives the apprentice extra rights and the employer extra obligations. Apprentices have the same rights as employees to things like trade union membership, time of work for certain activities, grantee payments, suspension on medical grounds, maternity rights, and discrimination at work. Apprentices also have some extra rights, such as the right to extra compensation if dismissed, and the right to be instructed. Unlike an ordinary employment contract, an apprenticeship contract must be in writing and be signed by the apprentice and employer, and usually by the parent or guardian as well. If there is no written contract, the employee can still use the law to enforce their normal employment rights, but they won't have the extra apprenticeship rights. That is wrong, because there may be circumstances where the actual signing may not occur as an apprenticeship. So let us look at pay and the minimum wage. Under the national minimum wage, an apprentice is entitled to at least £6.40 an hour if they are either under 19 years, if they are age 19 or over, and in the first year of their apprenticeship. After that, they are entitled to the normal rate of the national minimum wage, which is consistent with their age. Let's look at more information about the national minimum wage. Let us also look at benefits in kind. Let us look at work benefits such as meals, tips, and childcare vouchers. So vouchers actually don't count as towards the apprenticeship national minimum wage. It isn't clear how accommodation provided by an employer with a job will be treated for an apprentice. For other workers on the national minimum wage, there is a maximum daily amount the employer can charge for accommodation. More about the what payments count. More on what payments count toward the national minimum wage. Which hours of an apprenticeship count toward the national minimum wage. An apprenticeship combines work with on and off the job training. Apprentices are paid for all the time they are on the apprenticeship, including training time. All these hours count towards the national minimum wage. If time spent studying, for example, at college or at evening classes, is part of your client's apprenticeship, this counts as training time and counts toward the national minimum wage. In other words, they get paid at the national minimum wage, even if they are training or studying, as long as they are doing so within while actually working as apprenticeship, working as apprentice. Let's look at the length of contract. The length of a contract varies with the skills of the apprenticeship with the apprentice, the qualification and the industry sector. Generally, they last 1 to 5 years. Often, the contract lays down a definite length for the contract. The length can also depend on the apprentice passing exams. So if you keep failing your exam, probably you will be cut short. Let us look at training. The employer has a real obligation to provide training. In many cases, an industrial training organization, trade association, professional society, or trade union sets what the training should involve. The Institute for Apprenticeship oversees apprenticeship standards and assessment plans. You can look through all published apprenticeship standards on their websites. If the employer is a member of a trade association, they must offer a training, pay release courses according to the association rules. If the apprentice isn't satisfied with the training being offered, they should check with the relevant association to find out exactly what the employer should be providing. If the employer doesn't carry out their training obligations and dismisses the apprentice, your client might be able to claim damages for breach of contract. So if you're in such a situation, you can claim damages for breach of contract. You may also need to show your future earning capacity has been reduced. Usually, the apprentice wants to complete the apprenticeship as this will improve their future earning prospects. In this case, it's best to make a diplomatic approach to the person responsible for training in the employment firm. If this fails, it might be possible to improve the training by bringing pressure to bear through the industrial training organization, trade association, or trade union. Let us look at exams and modular apprenticeships. Sometimes the contract will say the apprentice must attend college regularly and get certain qualification during the apprenticeship. On finishing training, apprentices or employers can apply for apprenticeship certificates, England for certificates. If the apprentice fails any of the required exams, the employer might end the apprenticeship. However, some schemes have national agreements which allow apprentices to resit exams. For example, for more information, the apprentice should contact the relevant body. If there is no such agreement, the apprentice could try to negotiate with the employer to extend the apprenticeship and resit the exams. Let us look at health and safety of apprentices. The employer's health and safety obligations extend to apprentices. The statutory requirements controlling conditions in, for example, factories, offices, or agricultural establishments are enforced by the Health and Safety Executive HSE. You can get details of the legislation and how to enforce it from the Health and Safety Executive. You can get HSE info line Capillary Business Park Capillary CF 833GG. These are some of the information online. In terms of striking, the apprentice who goes on strike is in breach of the contract in similar ways to any other striking employee. Some contracts specifically preclude apprentices from striking. Others might need an apprentice who goes on a strike to make up the time lost by adding it to the end of their apprenticeships. Let us look at employer insolvency. The apprentice's rights on the insolvency of the employer are the same as for any other employee. It might be possible to transfer the apprenticeship to another employer. More about rights on insolvency of an employer. Looking at transferring an apprenticeship to another employer. An apprentice can only be assigned to another employer with the apprentice's consent. This is quite common in some trades. Let us look at discrimination. The law on equal opportunities and discrimination applies to apprentices in the same way as any other employees. More about discrimination, let us look at redundancy. If the business of an employer shrinks and changes so it can no longer train and supervise the apprentice, the employer can make them redundant. But if the employer could keep the apprenticeship on and provide training but simply fails to do so, the apprentice can sue for breach of contract. In practice, it is better to try to transfer the apprenticeship to another employer. It might be possible to approach the relevant industrial training organization, trade association, professional society, or trade union for help with this. The employer might also be able to help. Let's look at apprentices' rights on redundancy. If an apprentice is made redundant because the apprenticeship comes to an end, the conditions for getting a redundancy payment are the same as for the other employees. This means apprentices who have worked for the employer for less than 2 years don't qualify for redundancy payments. It might also be possible for an apprentice who is made redundant to have their contract transferred to another employer. Let's look at more. You can look more for information and understanding of redundancy. Let us look at dismissal. An employer can't rightfully dismiss an apprentice unless either the contract allows dismissal in specified circumstances, the apprentice's behavior makes it impossible to go on with the contract. Examples of this sort of behavior could be theft, persistently not doing the job, or failing to study. The courts have decided some behavior which would justify the dismissal of an ordinary employee wouldn't justify the dismissal of an apprentice. This could include isolated ruthless or bad timekeeping. If an apprentice is dismissed, they can claim unfair dismissal if they have been apprenticed to their employer for the qualifying period. If there is no fair reason for dismissal, such as conduct, capability, or redundancy, tribunals have sometimes decided to dismiss. Dismissal will be fair. Dismissal will be unfair. They have taken into account the special relationship between the apprentice, and the employer. So we are looking at the apprentice might claim wrongful dismissal rather than unfair dismissal if they haven't worked for the qualifying period. This is because the employer has breached the apprenticeship contract by ending it early. However, the apprenticeship contract might contain a clause which allows it be ended early, for example, because of misconduct. In the case of both unfair dismissal and wrongful dismissal, the apprentices might be able to claim compensation for a lack of notice, loss of earnings for the remainder of the contract, compensation for loss of training, compensation for loss of prospects. This was decided in a case which you can look online on gov.uk and similar information sources online, where also can look in detail about wrongful dismissal. So let us look more about dismissal and the qualifying period for claiming it, which is what you can find out more online when an apprentice can leave. The contract of apprenticeship normally binds the apprentice as much as the employer. In other words, the apprentice is normally obliged to work for the employer until the contract expires and cannot leave unless the employer's conduct indicates that they are no longer able or willing to teach. If the employer's business diminishes, and also this doesn't necessarily give the apprentice the right to leave unless it becomes impossible for the employer to continue providing training. In theory, the employer can sue an apprentice who leaves for breach of contract. Few employers are likely to go to this trouble, especially as it could be difficult for the employer to prove the suffered loss. If an apprentice just break the contract by leaving the job, they might find it hard to find a new apprenticeship if it's known they left one previously. So what now happens when the contract expires? If an employer gives an apprentice a job when the apprenticeship ends, the time they were or an apprentice counts toward their period of continuous employment. This affects employment protections like unfair dismissal, redundancy, and maternity right. Whether or not the time spent as an apprentice counts toward things like holiday entitlement depends on the employment contract. If an apprenticeship contract comes to an end and the apprentice isn't offered a job, in theory, the apprentice can claim unfair dismissal. In practice, unless the contract says the apprentice will be entitled to continue working for the employer, this is unlikely to succeed. The apprentice would need to show there was work available that they could do and that it was unfair of the employer not to offer the job to them. Where an apprenticeship contract comes to an end and the employer doesn't offer the apprentice a job, and the apprentice can't claim a redundancy payment. This is because there is no redundancy. The contract has run its course. Next time we are meeting, we are going to look at self-employment as an employment status, and also the right accompanying self-employment. Stay tuned. Thank you so much.
Yeah.
we have been looking at work in the United Kingdom. If you live in Britain, and also if you live elsewhere, such as in Europe or somewhere else in Africa, what happens in the United Kingdom is similar to what happens in your country. And so we have looked up today, we are looking at a 0-hour contract in many different elements. Next time we are meeting, we will be looking at self-employment, like I said. And thank you so much for coming. If you haven't subscribed to this channel, subscribe. And let us look at employment, continue studying it. And if time permits, we will be doing one or more different things, like looking at how to reflect on the points we will have discussed. But the next video is going to be on work, and at some point we are going to do a review and also a reflection on what we have discussed. Work is important on this program because of the idea about income. It is the primary source of income in the United Kingdom. Like I have said previously, if you watch this video, watch with the rest of the video also, because they are continuous, they are a continuity in terms of a product. And leave a comment below, let me know what you think. Also, if you are new, subscribe to the channel, and if you're watching, share with family and friends, and click like, click notification bell, and let me know what you want to do with this platform. If there is something you have noticed, let me know if you want something specific. But generally, it's best to go online to do further reading. Like I've made referral in the UK, we're talking about gov.uk. In your country, you look at the website for your government, and also other relevant website. You can read the website of the United Kingdom and other charitable organizations or other private sector organizations website in terms of employment and rights of their ed. It is important because employment is a very critical factor of modern society. You have to work to earn a living. Is a social factor. Is also an economic factor. Leave a comment below your views about employment as a factor. We have talked about technology coming to take away work as an economic infrastructure technology. And this is, in my opinion, is probably a good thing, but we need to prepare when there will be no work in the future. Going forward now, it's going to be harder and harder to find work, at least a decent work, which the machine may not be able to do. May not be able to do, but a lot of the work, like in the United Kingdom, retail, hospitality, and all these other, even in the IT sector, work is now disappearing because machines are becoming more capable. And leave a comment below what you think about technology. If you know something about technology, nanotechnology, artificial intelligence, 3D printer, and robotics, and all these are now things which are happening. Artificial intelligence, especially in nanotechnology, is very effective. And if you visit the website, be an expert on these machines, because they are the future of employment. And understanding employment in law and also at policy is extremely important, especially for the younger people, for the next generation. Because if you are also retiring, if you are working now, you may not be able to access legal support, because it is so difficult to get lawyers on employment, because it's a highly specialized area. If you watch this video, you will notice how complicated it is, and this is just a preview. But in terms of actual employment law, which is raw, you may not even be able to deal with the situation. So, and also to pay the lawyers, because there is a problem with access to justice because of failure of legal aid when you are disputing with your employer. So to be an expert on employment law is a very sensible thing. Go online, read as much as you can, and understand as much as you can. Take an interest on employment issue, especially work generally. We are going to look at self-employment next time. Like I said, each part of work, as employment status or work status of work. And thank you so much. See you in the next video. Thank you. Bye bye.